Good morning and welcome to the 31st meeting of the Constitution, Europe, External Affairs and Culture Committee in 2025. We have received apologies from Stephen Kerr, MSP. The only public item on our agenda today is to begin taking evidence on an inquiry into the legal mechanism for any independence referendum. And we are joined in the room by Professor Nicola McEwen, Professor of Public Policy and Governance at the University of Glasgow, and Dr Elisenda Casanas Adam, I hope I've got that right, Senior Lecturer in Public Law and Human Rights at the University of Edinburgh. We're also joined online by Professor Andrew Blick, Professor of Politics and Contemporary History, Co-Director, Centre for British Democracy, Department of Political Economy at King's College London, and Professor Alan Renwick, Professor of Democratic Politics at University College London, and a warm welcome to you all this morning. I wonder if I could begin by asking, our evidence so far has included discussion around understanding the settled will of the Scottish people, and in order to gauge the levels of support for triggering a referendum, we've heard that the definition of settled will is somewhat abstract, and I just wondered if you had any views on that, or what you think would be the trigger for a referendum. I'll go to Nicola first, perhaps.
So I don't think we can define what constitutes a settled will, or even make that a precondition. I think what ultimately will trigger a referendum, should there be one, is political circumstance and political opportunity, and that might come in a variety of different forms. I was thinking about this morning because I read the previous evidence when that discussion took place, and in the aftermath of the second secession referendum in Quebec, where the yes vote lost by less than a percentage point, the Premier at the time talked about winning conditions, which is a little bit similar, and I think it's more about, I suppose, not so much a precondition of a referendum, but perhaps a wisdom in that it's, in 2014 the referendum was decided to take place at a point when support for independence was nowhere near majority support. So it was a political gamble that ultimately paid off, because it then helped to elevate support for independence. We're in a very, very different place now, where the costs of losing a second referendum would be much greater than the costs of losing the first. So I think it's all about political calculation, really. I don't think it's certainly not anything that could be settled in law, but it's probably just a matter of political debate and political choice.
So obviously the first referendum was agreed with Westminster. Who do you think had the biggest political gamble in that? Do you think it was the government in Scotland, or David Cameron in signing the section to allow it to go ahead?
Both, I suppose, and both saw political opportunity. So I think, so for David Cameron, I think it was a judgment informed by the state of support at that time that he made the judgment. But I also think there was something about the majoritarian political culture in the United Kingdom that recognised that a majority was a majority, and therefore a right had been earned at that time. Now, that doesn't mean, and as I said this in my evidence, I think that because that was his judgment at that time, that doesn't set a precedent that we would expect to be followed by any subsequent Prime Minister faced with the same choice.
Thank you. Elisenda, do you want to ask?
Yeah, thanks very much. In regard to the question of settled will, I mean, I think I would agree with Nicola and with the comments that were made in the previous evidence session. You know, that it's something that it's unclear, it's hard to define. No one knows exactly what it means, what the threshold is. What I might add to this, because the question also expanded to the idea of what would be the trigger for the second referendum, because I think this is something that I'm aware was also discussed in the previous session, and I know there was a lot of discussion on the fact that legislation by Westminster would be required. We know that after the Supreme Court's reference, but maybe what wasn't raised and what I think is interesting is that in the current context, with the current sort of situation of vagueness or uncertainty, it appears that the decision on the trigger, what the circumstances, the conditions that would trigger the second referendum, are currently in the hands of the UK government to kind of unilaterally decide. And I would say that this is a concern, I think, in the context of kind of defining clarity. So, okay.
Thank you. Andrew, would you like to come in on that?
Yes, just generally to say, and I think this may be a recurring theme in dealing with these questions, is that, and I'm not in a sense adding that much to what went before, but I think I would urge the committee to really include the politics in all of this. That a lot of these decisions are going to involve politics and political circumstances in which these things happen, and the motivations of the different people involved, as you've already suggested, and constitutional mechanisms can help with these things, but you can never fully take the politics out of the Constitution. And I think any decision around what settled will means, if that's what we're looking for, is going to involve politics. I would say that there are mechanisms around that you can look at that try and establish, is this more than just a bare majority? And I suppose in a sense you could say the threshold requirement that was used in the 1979 devolution referendums was a kind of attempt to say there needs to be something more than just a bare majority of those voting. But I note that was then not used in 1997 for the referendums then. So maybe, particularly for Scotland, it wasn't necessarily a great experience. So there are mechanisms out there, but there's also politics, and that's not going anywhere. It's not. Rather, politics isn't disappearing. I'm not saying it's not changing, but it's not disappearing.
Okay, Alan, would you like to come in?
Thank you so much. Yes, I agree with most of what has been said. I think particularly it's important to recognise that the question about what settled will means and the question about what triggers might be appropriate are separate questions, and it's not clear that that the appropriate trigger would be attached to a notion of settled will. On the concept of settled will, I suggested in my written evidence that I think there are two ways in which this term is often used. So one of these is the idea that the majority that exists for a given position is a stable majority, and it's unlikely that that majority would flip in any kind of foreseeable circumstances. And the other idea is that the notion that this is the will of the people is broadly accepted across the board, including by those who don't share that particular view, whichever view it is. And I think there are good reasons for thinking that for some purposes, at least the first of those definitions of settled will should be a consideration. So Andrew was getting into there are questions around what the threshold in an actual referendum might be, going beyond the question of triggers. And I think there may well be a case for saying that before a decision is made, particularly a decision for change, there should be confidence that that is a stable majority in favour of that change, and that it wouldn't just suddenly flip back very quickly. I think it's a bit more problematic to suggest that you couldn't decide to make a change until there were broad agreement across the whole population that this is the appropriate way forward, and i.e. that those who oppose that change are kind of fully reconciled to it. That there's a danger there of being too conservative in your notion of settled will, I think.
Thank you. I'm going to move to questions from the committee. I'll bring in Mr Brown first.
Yeah, thanks very much, and good morning, panel. Just to say that I proposed this inquiry, and when I did, I posed the question, if the current constitutional arrangements are said to be voluntary and democratic, what is the route through which Scotland could choose independence? What is the mechanism? I don't know for any further forward than saying simply when Westminster decides it will happen. I'm happy to be contradicted on that, but that seems to be where we're at, both from the evidence from this panel and from the previous panel. And I have to say, I completely agree with, I have to call him Professor Roger, because I didn't catch the name there, the point made about politics being the driver in this much more than constitutional kind of nostrums. I think politics will be what drives it. But am I missing something, or is there some mechanism other than saying when Westminster decides there'll be a route? Nicola?
So I think so the point about Westminster deciding is a point of law, but I don't think that's a decision that's taken in the absence of other factors. So things will precede that decision, and I think that's, I guess, what we've just been talking about. So what would inform the decision, and that's where we would expect, whether that's election results within Scotland or some other demonstration of public opinion that suggests that this is, we've now got to the point where this ought to be facilitated in the context of the union being a voluntary union. Now, that doesn't mean that it would have to be. So that's where there is hierarchy there is ultimate authority with the Westminster Parliament. But the stakes, I think, at that point would be considerably higher, where they were confronted with what looked like an obvious will, I suppose, expression of will, as far as we were able to tell prior to a referendum. And you know, if that, so it's not a decision. Yes, ultimately that is the case, but it's not something that would be a decision taken in the abstract.
Alessandra?
Thanks very much. I mean, I think that it's an interesting question. I think in this context, so what was made clear last week, I think, was that there's no international right to kind of self-determination. So then it becomes an internal question for kind of internal constitutional law. And I think, yeah, the kind of black letter starting principle is that it's a decision for Westminster. But I think part of the evidence that I tried to submit is maybe there's a kind of movement or a shift in trying to approach these types of situations, because what also comes across, I think, from all the evidence in the way Scotland is unique, because there is this generally recognised kind of right for the Scottish people to decide their own future. What we don't have is a legal avenue for it to do so, and therefore it appears that, you know, we have to wait for Westminster to legislate, or for the UK government to agree to the holding of a second referendum. But I think part of the argument and part of the examples that I tried to put forward is that, you know, there are other principles in the UK Constitution that we can maybe try and draw from to argue that this situation, that the lack of clarity, the lack of uncertainty, that this kind of gap in the legal system is no longer appropriate. For a while, this was a situation that was maybe beneficial. Some people have argued this vagueness because it could work both ways. But I think in particular, after the Supreme Court's decision where they said that, you know, the Scottish Parliament didn't have competence to legislate, what there is an argument for some sort of clarity, some sort of framework, some sort of negotiation on providing a procedure that should say, well, these are the circumstances, so a pre-agreed procedure in which a referendum could take place, to somehow fill this gap. As I said, comparative examples may not be very helpful because this is a unique Scottish problem, that we have this gap. But I think there are strong arguments that could be based on, you know, the principle of democracy, because one of the things in the Supreme Court reference, they highlight, you know, the fact that an independence referendum, even if it was advisory, it would condition, you know, the legitimacy of the union, it conditioned the exercise of parliamentary sovereignty. But the similar argument could also be made that these subsequent kind of elections to the Scottish Parliament, where you have kind of pro-independent parties, pro-referendum parties that are gaining the majority support of the Scottish system, this is also something that needs to be taken into account as part of the broader kind of constitutional framework. thinking also about kind of, devolution, the idea of multi-level governments. So I think, the protection of minorities. I think there's principles within the Constitution on which we can draw to sort of build an argument that we need some kind of legal framework or legal procedure to somehow fill this gap.
Just before I come to other members of the panel, there seems to be no prospect of what you said of Westminster saying there have been continual elections which have produced pro-independence or pro-referendum majorities. There's no recognition at Westminster level that has any consequence at all. Do you see any political consequences from continuing to see ever more emphatic statements of support in elections for pro-independence or pro-referendum parties? Do you see what would be the potential political consequences, if any, for the UK establishment?
I mean, I think they definitely are political consequences, and I think this is kind of interesting sort of dynamic of the functioning of the UK sort of political constitution, because obviously this erodes kind of the legitimacy of the union, the continuity of kind of the legitimacy of the union, if we see this sort of clash between the will of the kind of Scottish people expressed through elections and the responses at the level of kind of the UK Parliament and the UK government. So I think there is this impact. There will be this impact. Obviously, the response is also sort of a political response, which again, would feed into legal mechanisms. So I think this is the interplay. I think it will have an impact. It should have an impact. Obviously, this affects then the future of the union.
And sorry, Professor Blick, I referred to you as Roger. That's the name that came up on the screen earlier on. Apologies for that, but be interested in your view on those two questions.
No need to apologise for that. So, on that point, I think if the question to look at it another way is, we are expecting or asking the UK level government and Parliament to actually, in effect, hand over the control it now has over when a decision that could lead to a territory leaving the UK, if we expect that to happen, that's quite high expectation. It may be the right thing to do, but to expect them to do it is probably quite unlikely. And my understanding of reading the evidence submitted by others to this committee and my own knowledge, I'm not an expert in this area, is that would be a pretty unusual arrangement internationally. I think, but also we need to look within the UK that were this kind of mechanism to be provided for Scotland, it does raise questions for other parts of the UK. I think Wales would be looking at that, and there would be people in Wales who might then say, well, can we have that, please? And also, as we all know, we have arrangements in place for Northern Ireland, which go, again, my understanding is internationally, they go quite a long way in allowing Northern Ireland to have control over its constitutional future, but the power to actually call the referendum remains with the Secretary of State, as is been discussed in some of the evidence to this committee already. The way in which the conditions in which the Secretary of State calls the referendum aren't very clearly defined. If we were to put an arrangement in place for Scotland that went a lot further in actually defining when such a referendum could be called, that would be quite interesting from the Northern Ireland perspective, because you may get an unevenness there. So I don't know what the answer to those things is, but I think if we have to see that this would take place in a wider context, which from the UK perspective it would be looked at very carefully before anything happened.
What do you think? What do you think the consequence, if I understood you correctly in the first part of your answer, you're saying that it's a high bar. I think you were talking about the power being transferred possibly to the Scottish Parliament to decide, or an agreed mechanism. Certainly, it's a high bar. If that bar is continually presented by the UK government, given the possibility of increasingly emphatic wins for pro-independence, pro-referendum parties, given what may well happen in Wales shortly, what is due to happen at some point in Northern Ireland, do you think that's what you see happening in future? Continual, if you like, refusal to countenance granting that high bar, or if not, what would change that? Do you think?
Well, I think that's where politics may come back in. And if, I was rereading David Cameron's autobiography before this session, and he's pretty clear that his agreement to hold a referendum was a political decision. He thought that, yes, there'd been an election in Scotland in which, the SNP had won, but he then talks about the desire to wrong-foot his opponents, the fact that in his view he wasn't entirely convinced that the SNP wanted a referendum at all, and the fact that he thought he was going to win it. So those were the politics then. That was Cameron's decision. As it turned out, perhaps his decision was a more risky one than he thought. I mean, he made the decision, interestingly, on the night of the AV referendum, and you can see why at that point in Cameron's career, referendums looked like a good way of dealing with problems, and why he then agreed to 2 more referendums, one of which, the Scottish one, didn't go as well as he hoped, and the other of which destroyed his premiership. So the context in which of politics can change. Now referendums look like a more risky proposition, perhaps, to a politician. But the politics can change again, and again, it's not my job to predict election results or tell politicians how to be politicians. But we don't know what's going to happen at the next referendum. We don't know what the parliamentary arithmetic is going to look like in the House of Commons after the next election, and who exactly is going to hold balances of power potentially in certain situations. So lots of things could come into play, but I still think that the politics will be there, and I remain of the view that the UK level of our system would be reluctant to do anything which is effectively handing over the control the Supreme Court decided they've got at the moment to actually allow this referendum to happen. I think that is something they would be very reluctant to do. We can get onto this as well. Could they actually do it in a way which is fully justiciable within the context of the UK Constitution is another question again. But I still think there'll be reluctance, and we come back to the politics. But politics can change.
Okay, thanks. Professor Renwick?
Thank you. Yeah, just going back to your original question, Mr. Brown, I do think there is a problem in current arrangements. It is accepted that this is a decision to be made by the people of Scotland, but there is not a mechanism for ensuring that the people of Scotland have an opportunity to make that decision. I agree very much with what Nicola said, that in many circumstances, at least, the mechanisms of politics will function in order to create opportunities. But there's no guarantee that those mechanisms of politics will operate in order to push a Westminster government to agree to a referendum, even in circumstances when it's very clear that there's strong support in Scotland for a referendum and for independence. If the government in Westminster is one that wants to, and to some degree depends upon support from Scotland, then presumably that government will care about what people in Scotland think, but it's quite possible to imagine a government in Westminster that doesn't have support on a significant level from Scotland and isn't particularly bothered about what people in Scotland think. And given the acceptance of the principle that the matter of Scotland's constitutional future is a matter for the people of Scotland to decide, that disjuncture seems to me a problem. So I agree very much with what Inasenda said on that. On the question of whether there's any route to the development of such a mechanism, I don't entirely agree with what Andrew said there. I think there are circumstances in which one could imagine that a UK government would wish to clarify. So, for example, if the UK government faced a demand from the Scottish Parliament for a referendum that it felt was strong enough that it couldn't simply dismiss it, but not so strong that it felt it had to accept it, then I can well imagine that such a government might want to negotiate around establishing some clarity on what the circumstances would be. And the mechanism isn't necessarily simply that the UK government turns the authority over to the Scottish Parliament. I'd be amazed, like Andrew, if the UK government and Parliament did that. But for the UK authorities to give some indication, as exists in the Belfast Good Friday Agreement, indicating that in certain circumstances a referendum would be allowed, I don't see that as impossible. But clearly it would be. Sorry, if I could just add one final point to that. Clearly, a UK government is in those circumstances going to negotiate a mechanism that ensures that it doesn't need to concede a referendum in that moment. So it's not going to be that it would concede a mechanism that makes it easy for a referendum to take place.
Thanks. My second and last question, and feel free to be quite brief in the response if you think it's appropriate. The Act of Union. In the last evidence session we heard, I don't want to put words in the mouths of those witnesses, but essentially it was to say it was pretty much a dead letter, irrelevant to this discussion. And yet in some of the evidence that's been presented, written evidence suggests that it has a bit more standing than that would suggest, including the need for its repeal if there was a successful vote for independence. And of course, the idea that it should be a right to self-determination in part rests upon the idea, rightly or wrongly, that Scotland or England voluntarily, I would question whether it was voluntary at all, but voluntarily entered this act of union between two parties, and so each party should have the right to end that and a process for achieving that. I just ask, what standing do you think the Act of Union has in this debate? And I ask that with the view that essentially this comes down to the UK government putting its finger in the air and deciding what it wants to do. That seems to be how much of the Constitution works in this country. But what standing does the Act of Union have? And I go back to Nicola first, if I can.
I don't have anything to add to what you heard from your three eminent constitutional lawyers last time.
Thanks.
Just briefly, I mean, I agree with the comments that were made in last week's panel by the other three, my three constitutional colleagues. What I maybe might add is, I mean, I think the main issue is it's not legally enforceable, so the courts have not accepted so. But I do think it provides an overarching framework which is relevant for this idea, because the Scotland Act obviously is our frame of reference at the moment, but the Scotland Act is very much about the Scottish Parliament, about the competences. So I think the Act of Union helps provide this sort of broader framework of saying, you know, this is a union state, you know, and there are some kind of legal sort of principles, references out there that help inform the Scotland Act, even if they're not legally enforceable. They're not something we can go to in law to bring before the courts to say Scotland should be able to hold a referendum. I think they're there in the background, but they are still constitutionally relevant in this sense.
Thanks. And Professor Renwick, since you're on screen.
I don't have anything further to add beyond what the lawyers said last week.
Thanks. And Professor Blick.
I am happy to leave it to the lawyers as well.
Thank you.
Thank you. Mr Whitby.
Thanks, Convener, and good morning to the panel. Mr Brown mentioned earlier about political consequences for the UK. I want to ask about political consequences for the UK government, political consequences for the Scottish Government or the party leading the Scottish Government, the SNP. It may be questionable for both when, Professor McCune, you talk about 1 in 5 ranking the Constitution as their top in their top 3 priorities at the moment. But to what extent do you think we are seeing or will see political consequences for the SNP government, in the sense that since 2016 we have seen the Scottish Government and First Ministers and leaders of the SNP not saying we want a referendum, actually going as far to say there is going to be a referendum, we will have a referendum, and that has not materialised. To what extent do you think that has undermined trust and support in the case that there will be a referendum from the governing party? There has been attempts to lead supporters up the hill for them to be disappointment in the statements that have been made by leading members of the nationalist movement.
I don't think there's any evidence to suggest that any drop-off in support for the SNP is a result of the things that you suggest. and support for independence is a lot higher than support for the SNP at the moment. That wasn't the case a while back, but there's not. I mean, I'm not aware of there being any evidence to suggest that that's the diminution in trust in the Scottish Government that we have seen has anything to do with the scenario that you just painted. I don't see that at all.
And in terms of, I think there's a sense that to some extent the SNP's domestic record on public services, which is probably the main reason why we've seen support from the SNP dip over recent years, has been the main factor there. But there has been a sense that in order to maintain itself in power, the SNP needs to dangle this independence referendum carrot to try and stay in power. And so far we've had, for example, John Swinney saying the next election SNP majority will deliver another independence referendum. He's even excluding the Scottish Greens from that mandate. It's just purely the SNP now. To what extent do you think there is a potential for political consequences for the SNP in looking like they want to preserve themselves in power rather than push the case for independence?
Possibly, but again, we're not seeing the evidence of that. I mean, I think it sort of relates a little bit to the questions that Mr. Brown was posing, in that the tests that we've had so far have been parliamentary majorities for pro-independence parties, but not for the government, not since 2011. So I think the assumption is that the precedent, I don't think it is a precedent necessarily, but the decision that was taken after the 2011 election was in the face of a single party majority government, which in the sort of Westminster political culture usually means something in terms of mandate. And I guess the case being made is that in the repeat of that particular scenario, then it's a stronger claim. Now, we won't know whether that's the case or not until and unless we have that result. I do think that the political risks on both sides, I suppose, but and particularly the political risk of rejecting a claim become higher in the context of that majority, particularly if it's matched by a clearer majority among the people of Scotland, consistently expressed, which we don't have at the moment, and also with time. So I think the further you get from the 2014 referendum, the more tricky politically it is to say, well, the decision was already made. So I think it's just the passage of time, I think, in that as well. But we're not. I know the point you're asking, and is there? I mean, ultimately we will see if that carries a risk in the election itself. But there's certainly no evidence at the moment that that's the case.
I think on that last point, I think to some extent those in the nationalist movement are using things like these inquiries as a distraction from building the actual case for independence. To be perfectly honest with you. The SNP have said, or John Swinney said he's going to get a majority, he's going to deliver independence again, similar to what he said in the past. I don't believe the SNP are going to get a majority at the next election, so I don't think we're going to cross that bridge. But John Swinney has said he has got a secret plan to deliver independence after the referendum. I don't think he has any plan, but I'm happy to open it up to the panel if they want to tell me what they think John Swinney's secret plan is.
I don't think any of us are going to be privy to any secret plans or otherwise that the First Minister has.
Any idea what it could be?
My assumption would be that it would be to make the same claim as was made in 2011 after the SNP secured a majority, and to hope that the Prime Minister of the day made the same judgment as Mr Cameron made. There is no guarantee that that would be the case.
No, my understanding, though, is he's already said that publicly, Professor McEwen. What he said is if the Westminster government don't agree to that, he has a secret plan to do it.
I don't know what that would be.
Right.
I guess you asked.
Does anyone else in the panel have any idea what that secret plan could possibly be?
If we did know, we couldn't tell you.
Yeah, sure. Sure. I think he doesn't have one. But thanks, Convener.
point, Mr. Biddy. George, did you want to... And, oh, sorry, Alessandra.
Could I intervene just briefly? It's not on the secret plan. Sorry, I don't know anything about the secret plan, but it was just a comment on the discussion. And obviously, I'm a lawyer, so I can't talk so much about the political consequences. But I think maybe it's a comment that's relevant to the discussion, and maybe speaks to the different reasons for kind of clarifying a mechanism that could enable the referendum to go ahead, and that maybe the reasons are not only kind of on the pro-independence, pro-referendum side, because there's also an argument for saying, let's reach an agreement on this, let's clarify the mechanism, and then that means it's agreed and it's taken out of the political space. Because I think that the point that you were making is we've had this ongoing debate focused on procedures. It's not about the case for independence, it's how can we hold an independence referendum under the constitutional framework. And obviously we have had, a Scottish Government trying all the different potential sort of avenues that could make it legal, like trying to kind of get an agreement on a Section 30 order, then going to the Supreme Court and getting clarification on the competence question. So I think there is also an argument, because this is ongoing. How can we trigger? How can we push a mechanism that enables this to go ahead? I think there's an argument also on the other side to say clarifying this removes it. Let's move on. Let's talk about something else. Case for independence or not independence, or let's focus on other issues.
And if I may just ask one last question, I think that leads on to the point just generally. I think the EU referendum, I assume you would agree from that point, I think the EU referendum showed that actually people need to know exactly what they're voting for, and it needs to be, because there was a whole issues at post the EU referendum and projected discussions and negotiations about what that actually meant in practice. Would the other panel members agree on that?
You can't ever know exactly what you're voting for, because if we are to assume that a referendum would be a test of the popular will, then unless you have two referendums, which is one option, then you wouldn't, the referendum necessarily, at least one referendum necessarily, would take place before the negotiated settlement. You can, I do think, I agree with you on the example of the Brexit referendum. There was really no proposition at all, and I think that's because it was a device used by the government of the day to resolve a political argument within their own party, rather than a proposition that they themselves had. So I do think we should expect the referendums to come with proposals that are plausible and can be defended and can be subject to scrutiny, but we can't ever know exactly before the negotiations take place.
I think Professor Blick and Professor Renwick both want to come in on this one. I'll come to Professor Blick first.
Thank you. Just very much to agree with what Nicola just said then. We may come back to the two referendums question, which I think is interesting itself, but this kind of referendum can be contrasted with, say, the AV referendum in 2011, where we actually had an Act of Parliament already been passed, which actually set out what the AV system was like, how it would work, and provided that if there was a yes vote in a referendum, it would actually come into force at the time of the next election. Obviously, we don't know exactly what that would have meant politically, but we knew what was going to happen. You can contrast that very clearly with this kind of referendum, where there's going to be another party involved, i.e. the remaining UK, that's going to want to negotiate. So you can't avoid the fact that things are going to happen after the referendum, if it's a first referendum after the first referendum, that we can't predict in advance. There's no way around that. And admittedly, the EU referendum, certainly more could have been done to give ideas of what might happen, but it's unknowable. And I think you're setting there, and if you're expecting to be able to tell people in advance of a Scottish independence referendum exactly what an independent Scotland is going to be like, you're setting an impossibly high bar to meet. Certainly you should try and I know Alan's done a lot of work around this, you should try and communicate as much information and educate voters as well as you can in advance of it, but you just can't tell them with certainty what would be the outcome of negotiations. So I think it just really is to hopefully to reinforce what Nicola said.
Okay, Professor Renwick.
Thank you. Yes, no, I agree with all of that. And I think so you can do a lot during a referendum campaign in order to improve the quality of information, the quality of discussion. I mentioned the possibility of using citizens' assemblies or other similar kinds of deliberative processes in the course of a referendum campaign or in the run-up to a referendum campaign in order to facilitate that. But it's Nicola and Andrew are absolutely right that this is a case where aspects of what the change option would be on the ballot paper cannot be clear at the stage of a referendum. And I would seriously think about two referendum processes, which have been briefly alluded to there. So the idea would be that you have first a referendum essentially on the principle, do we want to go for independence? And then you have a period of negotiation and working out the details. And then you have a second referendum on, do we confirm that we wish to go ahead with this at the end of that process? And you can raise all sorts of questions and doubts about how would this really work tactically, and how would it play out? And I think it's important to kind of work through those questions about how it would work out. But I do think that kind of process should be given serious consideration. If I could also just quickly go back to what Alessandra was saying about the difficulty with the current arrangements, that questions to do with the process of independence and independence itself are kind of constantly on the table, and that can get in the way, as Mr. Bibby was suggesting, of kind of day-to-day policy making. And I think this is a concern. And just one point that I would add to what has previously been said on that is, if you have mechanisms that establish when a referendum can take place, then you can also establish a minimum period between referendums. So in the Belfast Good Friday Agreement and in the Northern Ireland Act, that period is set at 7 years. So that is intended to ensure that you don't just have a constant run of referendums. To me, that's actually quite a short period between referendums, given just how momentous they are on these sorts of issues. There's also, of course, been lots of talk about leaving it for a generation between referendums. That sounds like a rather long period to me. But, a UK government thinking about does it want actually to establish mechanisms here might well think that it would be useful to establish some minimum time periods in order to be able to manage a debate around this issue a little bit more.
George, can I just clarify, did you want a supplementary on this?
No, I've got another question.
Okay, right, okay, so come to Neil and then to Jamie.
So, thanks, Convener. It was just on the issue of Northern Ireland and the Belfast Agreement there, Professor Renwick. Appreciate obviously the evidence you're giving on that, and it's obviously helpful. I just think that sometimes the situation in Northern Ireland obviously has a very different historical context to it, and I think sometimes we need to that is perhaps kind of it's wrong, or it's just not the same situation in Northern Ireland that is in Scotland, and I think we just need to take cognizance of that, despite obviously there being arrangements there.
Yeah, no, I totally agree with that, and in many respects, I wouldn't attempt to follow the arrangements in Northern Ireland. They are absolutely products of very particular circumstances. But, in some respects, they can be a useful source of thinking about what options may be available.
Yeah. Thank you.
Does anyone else want to come in?
Respond to, so I think going back to your question, Mr. Bibby, about this potentially being a distraction used politically, the obvious response to that would be, as Ellison and Alan suggested, is to devise then a mechanism. The only way that then becomes depoliticised, if you like, is if it's done by consensus. So if a mechanism was devised by the UK government alone, then it's probably unlikely to take the issue away from the political arena. So I agree with you, the process issues can be a distraction. I don't think that well, I mean, I think if for those who support independence, I think there's a lot of work to be done on the question itself of substance rather than the process issues. But I can see that being even more contested were a mechanism to be devised unilaterally by the UK government, the UK Parliament.
Dr. Casanas Adam?
Thank you. Just very briefly, because I know it was just on the comparisons with Northern Ireland. I mean, I would agree that obviously it's very different context, very different circumstances. What I would say here, or just mention here, is that obviously Scotland has its own context, its own circumstances, and here we have the very strong precedent, I think, of the 2014 referendum, which is recognised comparatively as a kind of paradigmatic example of a sub-state referendum and negotiation and deliberation. So I think that also acts as a very strong precedent for current debates in Scotland on this.
Thank you. Jimmy?
Thanks very much. Just following up some of the questions, I thought Neil Bibby was very unfair on the panel to ask you about the SNP secret plan. I mean, we've got Keith Brown, the deputy leader of the SNP. I'm sure he knows it, and he can tell us at some point anyway. But I was going to ask, in fact, Nicola, if I could come to you first on this one, and perhaps others can come in if they want to. Neil Bibby asked about the kind of or talked about the kind of failure to deliver. We've 11 years now since the referendum. We've only got this inquiry being brought forward now in the last few months, I suppose, of the Scottish Parliament. We talked about the politics of independence referendum. Do you think, actually, for the SNP over the last few years, it's been more interested in talking about independence than actually delivering it? And that's obviously something that's been an increasing concern for some of those within the nationalist movement.
I think that's a matter for political debate rather than for our academic expertise, I think.
But I mean, I think what we've established is the legal right to call it an independence referendum is with the UK government. This is all about politics and the political debate and political will. And if you have essentially the self-appointed, but understandably self-appointed main party looking to deliver independence, not actually fully really committed to delivering what they've been talking about, that obviously impacts on the political debate.
I guess I would just reiterate some of the comments of the other members of the panel earlier, that if we understand the United Kingdom to be a voluntary union, it is a legitimate question to ask, to pose about the circumstances in which the decision to remain or to do something else would be exercised. It's not an unreasonable question to ask. I think the other parts of your question, I think I'll leave to politics.
Okay. If I could just ask briefly, and I've got some other questions I'd like to ask, but Dr. Casanas, Adam, you talked about Scotland having the right or the need. I'm trying to remember exactly the words. I've written it down here somewhere, but I'm not sure in my scribbled notes where I can find it. But it being right, there is an opportunity to trigger a referendum. I mean, I come from Orkney, and I don't know how much you know about the constitutional position of Orkney, but obviously we weren't always part of Scotland. We were part of Norway. We were, depending on the kind of how you presented, either annexed or given away by Norway. Do you think we were the most strongly unionist part of Scotland? Do you think those parts of Scotland that perhaps do value being part of the UK more than others, or might seek another constitutional future, as we've been seeing in Orkney, talk about a different position, something like more akin to an overseas territory? We're seeing that in Shetland as well, looking at more autonomy. Do you think those parts of Scotland that have a distinct heritage should also have a right for self-determination?
I don't know if I would talk about it as a right to self-determination per se, because I don't think I think in the constitutional framework, how we have to approach these territorial issues, these sovereignty issues, both in relation to Scotland within the kind of framework of the Union, but also in relation to Shetland and Orkney, is through dialogue, so through balance, through negotiation, And obviously one of the principles that I kind of put forward in some of the approaches to the resolution of these issues is also the kind of protection of minorities. And this involves then also the protection of minorities that may result, or minority territories, from any change. And I think what's also important to take into account that maybe hasn't come up so much in the discussion, I believe, so far, although it did come up a bit in the previous sort of evidence session, is maybe the connection between sort of internal management of territorial diversity, of national pluralism and independence, and how they are somehow connected. So there's debates about different ways of articulating relationships between different parts of the territory, different nations and the centre, and also within the different nations, those different parts of the territory within the kind of broader nation or subunit itself. So I think there's creative mechanisms that can be used. There's intermediate options and solutions that can be designed that are tailored to specific territories. I don't think anything should be off the table. I think the important thing is kind of negotiation in good faith and sort of tailoring the organisation of government in accordance with majorities, but also taking into account any relevant minorities.
Thank you for that. I suppose, you know, from a purely moral argument, is the right of, say, Orkney and Shetland for self-determination any weaker or stronger than Scotland, given Scotland is a very diverse country. It's got, I mean, the regions of Scotland are very different backgrounds, Gaelic background, Viking, Norse heritage as we do, etc. Do you think that the kind of moral arguments are any stronger or weaker for those communities?
I mean, I would argue they're strong as well. I don't know if stronger or weaker. I mean, I'm not so much an expert on those territories because my focus has been on you know, Scotland and Catalonia, but I think there's a strong argument also for the protection of internal units and minorities.
I was just going to say that Dr. Casanis Adams and I were both part of a group that was exploring a code of conduct or a code of good practice for thinking about self-determination claims. And within that, there's lots of really interesting things around values and principles and things underlying. I mean, I think in the case of Orkney and Shetland or any other part of Scotland that might consider itself a nation and want to express self-determination, I think there are two parts to that, I guess. One is whether we think in the context of triggering independence, it's sufficient that you need to consider geography within that. If you know, you want to have any additional qualification in terms of 50+1, but is it okay if that 50+1 is entirely in the central belt, or might we have some other? I think having majorities in every region is too high a threshold, but there's a reasonable case to make around thinking about, not least to try and ensure that there is consent and legitimacy throughout Scotland, that there's some sort of diversity there. But ultimately, it would be dependent on what was in the constitution of an independent Scotland. So would that constitution, one assumes, would have to say something about where it saw its case for territorial integrity. Would it follow many of the constitutions of the world and remain silent on the issue of secession and just hope it doesn't come up? Or would it prohibit secession, as many do? Or would it have a mechanism, as very few do, but some do? And you know, those are the sorts of things that you might think about as I mean, I think there would have to be some sort of process or convention at the point of developing a constitution for an independent Scotland that wrestled with some of these issues. But any government in any territory, whether it's the United Kingdom government in relation to managing the whole of the UK or a government of an independent Scotland, they would have to take into account the territorial diversity within that country and find ways to, as Dr. Cassandra Adams was saying, to find ways to recognise and value the diversity within it, and to give voice and expression, whether it's through self-government or some other means.
So thank you for that. I mean, given that the UK government previously, I mean, the late Joe Grimond did quite a lot of work around this previously, has recognised there is different, I suppose, with Orkney and Shetland because of their background. You don't think that decision should be made at the same time? For example, if there were to be another independence referendum, that decision should be made in terms of that option should be there for them.
I don't think so, because then you would have so there would all potentially be contradictory. So in a sense, if people were voting on a decision for should Scotland be an independent country, you need to have a sense of what Scotland is. And if that Scotland might be something else, if the boundaries were to be simultaneously redrawn, I think that blurs the question itself. So I think sequentially, I mean, if you were to have that at some point, that would be a matter for.
But that causes very much the same
Scotland.
problems that we talked about in terms of, and I try to remember who it was. I think it was about a confirmatory referendum. You want to know not exactly. You want to know as far as possible what leaving the UK means for Scotland. It could mean a whole load of political, financial, etc. issues. It could mean parts of Scotland leaving in the future. You're never going to have that certainty, I understand, but actually would it not be more suitable to have that referendum at the same time so people could vote and say, well, we think Scotland may be smaller than it is now?
So I don't think so for the reasons I've given, but other members of the panel might have a different view. I also don't favour a confirmatory referendum, actually, because in everything I know about intergovernmental relations, I find it hard to imagine a scenario where you have meaningful negotiations on independence take place when it's all still to play for in a confirmatory referendum. So I am more sympathetic to having some element of certainly deliberation in advance of a referendum or during a campaign, but some way to ensure that it's not just a geographically concentrated majority that are deciding for the rest. I think there has to be some sort of consideration of the different perceptions, interests, preferences.
Thank you.
Nick, I think you wanted to.
Hello? What did you want?
Yeah.
Oh, thank you. Sorry, I was just waiting. Said there about confirmatory referendums, but I won't. And I think
losing the sound a little bit. Sorry, it's breaking in and out at the moment. Do you want to repeat
I'm so sorry.
what you said? It's okay.
So just to respond to Mr. Hackford-Johnson's question, so clearly there are matters of principle, and then there are matters about how those principles apply to particular groups of people. So there are matters of principle around the appropriate rights, if you like, of self-determination that groups should have, and then there's the question of, well, does a particular group have the same sorts of claims as another group? And I grew up in Wick, so I share a sense of the Nordic heritage and the difference from the rest of Scotland there. But I think it would be pretty hard to suggest that there is a sense of national identity or a sense of political identity demanding separateness in Orkney, Shetland, the other bits of Scotland with Norse heritage, that is commensurate with the kind of sense of national identity for Scotland as a whole. So I think it's very hard to make that kind of claim as applying to this particular group. But the underlying principles are the same principles as would apply for any group.
Oh, sorry. I'll just come back very quick. Sorry, I'll just move. I've got one other kind of brief question then. I mean, we started off this conversation about settled will. We then talked about broad agreement. I think we then went on to stable majority. So we've covered a whole load of different, I suppose, ideas of what would constitute perhaps support for independence, or that kind of public support for another referendum. One of the difficulties at the moment is, while independence can be polled on, and arguments are that it's fairly close between yes or no, or leave or remain, depending on how you're going to frame the question. It is not a priority for the Scottish people. We're seeing that it's well down 7, 8, 9 in terms of that. So in any, I suppose, identifying support for independence, is it important that not only the kind of overall what somebody would do or how somebody would vote in a referendum, should there be one, was taken into account, but also where it is in terms of the priority for the people? If I can perhaps come to Professor Renwick first, and then Professor Blick, and then panelists too.
Yeah, thank you. I don't have a strong view on that. I think it's an interesting question. I think it's a point that would need to be thought about carefully if any specific mechanism were to be introduced. It's clearly not part of the mechanism in the Belfast Good Friday Agreement, but as has already been pointed out, we shouldn't necessarily be following the Belfast Good Friday Agreement. I can see a case for including it, but I think I would want to think about it a little bit further before expressing a clear view.
Thank you. Professor Blick?
Whether it should be a top priority for voters before referendums called, I wonder how many referendums would ever have been called in the UK were that the case. And certainly if you look at the evidence on the European Union referendum, EU membership became a major issue for the public after it was already apparent that the referendum was going to be held. In other words, they were rightly thinking it was important because there's a referendum coming up. So I think I just don't see how that would work, and I don't think, and there's different issues around. There may be a smaller group of people to whom it's really, really important. How do you assess all those? How do you weigh this up? I think it's really difficult to do. So I think I can see some difficulties with. I agree, by the way, that issue is a significant one, and this is a problem with referendums generally, and we just don't know how important these things are. But often the reason referendums get called really, historically at least in the UK, is because of higher politics mainly. There is some relationship with public opinion, and obviously in the end the public get a vote on the matter, but why a particular referendum gets held at a particular time in a particular way has been left to higher politics and done in a very ad hoc way. Obviously today we're talking about the possibility of moving to a framework, which I think would be great if we can get it, but there's also lots of issues, lots of reasons why that's been difficult to get to, and why I think it will still be difficult to get to. That doesn't mean we shouldn't try.
Thank you. Dr. Cassidy-Adam.
Thank you very much. Sorry, I had a slight blank there. Do you want to go for it? I was just thinking through my ideas. Sorry, I was thinking and then it got lost. Do you want to go? I did have it all written down and then...
Okay. No, I don't think so. And there's quite... Although I did include that chart in the evidence, there's quite a bit of controversy within political science literature about those sorts of questions and how to interpret them. Not least because there's an implicit assumption in there that these things are discrete, and they're not. So you might have a view about the importance of the economy and think that the Constitution in some way relates to that, and that you can't. It's very difficult to pick that up in those sorts of blunt tools within opinion polls. So I wouldn't put that as a criteria. One assumes that if in the context of an election, and if a party puts forward a manifesto and a campaign that forefronts that issue, then that may be seen as sufficient to the importance of voters attached to it.
Okay. Did you want to go back?
Thank you, sir. Apologies, I just got completely lost in a train of thought and then came back to it. So I mean, I think the importance of the salience for citizens at the moment, I think it is important. And I think maybe we need to distinguish between setting out the kind of framework or the process, and maybe the fact that it's not a very salient issue at the moment means it's a good time. And I think Nicola mentioned this in the evidence, because you can have a more kind of paused debate. I think the problem is, in particular with debates about process, that when, it is a very salient issue, then it becomes really hard to just sit down and work out the conditions or the process. So I think maybe there's a distinction between drafting the process and the framework, and this is a good time. And obviously any process and any framework would then require the trigger conditions, and one would imagine that the trigger conditions would somehow need this to be a salient issue, there to be some sort of requirement. So then it would be this meeting of the requirements of this process that has been negotiated, hopefully in a kind of calm and consensual manner. I mean, the other point that I would make is obviously there are risks for both sides in holding this referendum, and you could imagine that actually maybe it is on the unionist side to say, well, let's hold this referendum at a time where it's not really salient, because if there is a second referendum with a second no vote, arguably that then does close the issue for a while. So there's also this double side to, who is taking the risk. So there's the kind of setting of the process, but also when the trigger conditions are met or not, but the interests of both sides in this context.
I admire your hope that it could happen in a calm manner, but thank you very much.
Mr Harvey.
Thank you. Good morning to our witnesses. I wonder if I could just firstly briefly reassure Mr Halkrow-Johnson that, if there is a genuine and sincere secessionist movement arising in Orkney or in Shetland or in both, if the goal is to establish how it would assert itself today, in the moment when that sovereignty lies at Westminster, I fully support that. That's exactly what we're trying to achieve for the whole of Scotland. And if the goal is to assess how it would assert itself in the context of an independent Scottish constitution, I would support a constitution that gives the right of a serious and genuine movement like that to test public opinion. So I think the answers we're looking for in this inquiry are exactly the answers you are seeking. I wonder if I could just come back to this phrase, settled well. It seems to me that we should be dismissing this just as a piece of political rhetoric, in the same way that some of our witnesses suggested we should in relation to once in a generation. These are political phrases used in debate rather than points of principle. And that's partly because, as some have argued, settled well is hard to define. It's partly because it's not the precedent either. Even in '97, I don't think anyone really was rock solid sure on whether the tax varying power would be supported by the overwhelming majority of the people of Scotland. AV certainly wasn't about establishing the settled well. It was a wheeze in order to offer people a voting system that nobody really wanted in order to protect the existing one. And the EU referendum in no way represents an attempt to define the settled well. It was a very, very open question, and since then has given rise to a majority for rejoin in many opinion polls. So shouldn't we dismiss this idea of settled well and the associated argument that Adam Tompkins gave us in an earlier session that we should only really ever use referendums in order to establish what we all already know? And the final aspect of this is that in the question of Scottish independence, where we all accept that a referendum would have to be agreed by two different governments, presumably wanting two different outcomes, then saying that it's about the settled well, that it's about establishing the settled well, is almost a recipe for paralysis, because you will never have a position where both governments are 100% confident that they represent the settled well. Shouldn't we forget this phrase altogether? Whoever would like to jump in. I'm looking at the people and I'm looking at the screens.
So I certainly don't think it should be a precondition, not least because we don't know what it means and we don't know how to quantify. So it doesn't help you, I don't think, to identify any mechanisms, because then the question just is then posed, well, how do you define and measure the settled will? And I mean, the phrase came from John Smith prior to the idea of there ever being a referendum on devolution and on a Scottish Parliament. So it was, I suppose, it was a case being made at that time historically that there was enough evidence to suggest that the people of Scotland wanted a Parliament. The referendum, as you might recall, was at the time controversial. With hindsight, I think it's given democratic legitimacy and underpinning to this Parliament. So, I mean, to an extent, I think I agree with you in terms of a triggering mechanism. I think the point that Professor Tompkins was perhaps also making was that it might inform political choice about how to proceed and how to secure the consent, not just of those who are on the side that advocates for the change, but those who might find themselves on the losing side of that argument were independence to succeed. So I sometimes wonder, an interesting thought experiment, what would have happened if in 2014 you had 50.1% yes vote. As far as we are aware, that would have been sufficient to trigger independence negotiations, but I'm fairly certain they would have been an awful lot harder to conduct in that scenario than where the majority was a little bit clearer.
Anyone else?
Thanks very much.
Yeah,
I mean,
thanks, Dr. Black as well. Sorry,
Okay.
it's okay. On you go.
no, sorry, it's just because the light came on. But just briefly, I mean, I would agree with everything that Nicola said. I mean, I agree it is unclear, and that requiring it as the kind of trigger condition for a referendum, you know, the fact that we have some kind of super majority or something, I also think is problematic, partly because it completely departs from 2014. And as I said, you know, internationally, you know, 2014 is recognized as best practice. So we have our own internal kind of model of best practice. So anything that kind of departs from this, I think would need some kind of deliberation, would need some kind of justification, I think, because if not, it's problematic. I do agree with the point that you made, and I think it relates to what Adam Tompkins was talking about in the previous session, which is, I think, maybe what he meant is this would be the kind of situation where it would be maybe impossible for the UK government not to provide a framework for, you know, Westminster Parliament, not to legislate if there was a really kind of high level of support for independence that came across in the polls. But I suppose this is not the situation where we are now. And I think the questions we're looking at now are slightly different, but I think they're just as important because we do have, you know, people who have consistently come out and voted in favour of pro-independence parties. So we still have that democratic tension. It's a slightly different one. I mean, I was just thinking a similar kind of situation arose in Catalonia, sort of leading up to the kind of controversial Catalan referendum, and we all know what happened. But it was a very interesting debate there because there was not a very clear majority support for independence, but there was a very high majority support for a referendum. Okay. And there were a number of people that wanted a referendum for different reasons. There were those who wanted independence, but there were those who just wanted to put an end to them. And I think that created a different kind of sort of democratic tension, because it's saying, okay, maybe there's not a majority in favour, but there is a sustained majority in favour of a referendum that the system somehow needs to respond to.
Either of the online witnesses want to jump in at this point?
I think Andrew wanted in. Yeah.
Yes, please. Just to say that I think it's probably a good idea to get away from the settled will as you know, terminology. I think it would be very difficult, and this comes back to my point about I think the reluctance of the centre to actually hand over legal power. It'd actually be quite difficult to define legally if that's what we're looking to do. After all, we thought we had the Sewell Convention written into law in a way, and found out, well, it is written into law, but the Miller case told us that the Supreme Court didn't actually want to make it justiciable. So there's that issue of defining it. And just generally getting an agreed, you know, or even below legal definition, getting agreement about what it means. Who knows? It could be like the 5 tests for joining the euro or something like that. Who knows? But beyond that, however, that doesn't get us away from the point that this is a really important decision, would have to be taken seriously. So there's that issue. And coming back to the point about the unknowability, the precise nature of what it would mean. So we've got a combination of, we know it's a really important decision, but we don't know exactly what it's going to mean. And also, again, if we look at other referendums, there is I suppose in a sense, it's an asymmetrical referendum, a bit like the EU referendum, in that one side wins. If Remain wins, if you want to call it Remain, then basically things carry on as they were. If Leave wins, then you have a huge change that might be very difficult or impossible error to reverse. So all these things mean that we do need to think about them very seriously when we approach the referendum. and we can't get away from all of those issues. Doesn't mean it shouldn't happen, but I think the actual settled will concept isn't necessarily that helpful and could lead just to an argument about terminology and not actually come up with an actually legally enforceable instrument, if that's what we're looking for anyway.
Okay, Professor Renwick.
Yeah, I largely agree with what has been said, and I was slightly surprised, to be honest, last time, 2 weeks ago, that there wasn't pushback on what Professor Tompkins said, because it seems just very clear that settled will is not the precedent. The precedent is that a simple majority is sufficient. And I think that means that there should certainly not be a supermajority requirement in any referendum, which I know is sometimes discussed. And it's sometimes suggested that supermajority requirements are quite common in referendums. This is not at all the case. The only country in Europe that has a supermajority requirement in referendums is Lithuania, on some very, very specific questions around the independence of Lithuania and Lithuania as a democracy. So there certainly shouldn't be that. I do think the element of settled will that is defensible as a criterion to be considered here is the stability of the majority for a particular position. And I think it's not unreasonable to suppose that for such a momentous change, it would be appropriate to ensure that the majority in favour of that is a stable majority. And you can achieve that by having a multi-stage process of decision-making. So I mentioned in my evidence, for example, the process for a constitutional amendment in Denmark, where it's necessary to have a vote in Parliament, then a general election, then another vote in Parliament, and then a referendum in order to get a change through. You could also consider embedding stability in the mechanism if you had a mechanism for triggering a referendum. So you could have a requirement that there should be evidence of a sufficient level of support for independence that extended over a defined length of time. So I think these kinds of elements of the notion of settled will are defensible. But fundamentally, if the majority wants Scotland to be independent, then Scotland should be independent, or should become independent, and there should be a mechanism that allows that to take place.
Well, that answer comes on to the second question that I wanted to explore, which is that the principle that the people of Scotland have the right to decide, and that Scotland can become independent if the people of Scotland decide, is not ancient history. It's been agreed by all political parties elected to the Scottish Parliament. It's been agreed by both governments. It's been made explicit in the report of the Smith Commission. This is a right that has been given to the people of Scotland. But the people of Scotland are being told, you have that right, but you may not exercise that right. We will give you no means to exercise that right. And if an individual was being told that they have the right to vote, but we're not going to open any ballot places, we're not going to print any ballot papers, then the right is meaningless. I explored in previous sessions whether the political dysfunction around actually creating a means for people to exercise that right it could be broken by some kind of element of direct democracy or participative or deliberative processes. And I appreciate Alan Renwick's evidence in saying that there might be more value to formal processes like citizens' assemblies in informing a referendum debate than in triggering a referendum. I appreciate that. But is there any way, and I know I'm asking this slightly out of desperation, is there any way that the witnesses can think of to allow the people of Scotland to break the deadlock? Not necessarily a formal process that triggers a referendum, but just defining how it is the question can be answered, that if the people of Scotland have that right, how may they exercise it?
Professor McEwen, yeah.
Professor Renwick wants to come in first.
Sorry,
I
missed that, Professor Renwick. Sorry, please come in.
Sorry, no, I might just come in very briefly because I did talk about this in my written evidence, and in the written evidence I I looked at three possible mechanisms by which potentially this could be done: a referendum on whether to have a referendum, a petition of some kind in order to trigger a referendum, or some kind of deliberative process such as a citizens' assembly. I suggested that a referendum on whether to have a referendum sounds a little bit crazy, and I think it probably is. So I wouldn't do that. A petition. So, well, just to go to the third one, as you said, Mr. Harvey, I think seeing how a citizens' assembly could be used at this stage, I just struggle to see how it could be useful, because fundamentally it's a question of should we do X or not do X. It's a very binary question, and it's a question on which people have many people, most people have very entrenched views.
Forgive me for jumping in, but I was trying to stress in the way I framed the question that it doesn't need to be so much about deciding whether a referendum should be triggered, but about forcing an answer to the question, an answer that is absent from the UK government at the moment about how the right to choose, the right to decide, might be exercised.
So that would go back most plausibly, I would have thought, to the idea of a petition process, which is a mechanism whereby you can test the amount of strength of feeling on a particular issue. So as I said in my evidence, I would be very wary of a petition, a process that allowed a petition to lead directly to a referendum, partly because the threshold you would need to would be very, very high, and it just seems very problematic, but partly also because it's important to have moments of deliberativeness and for a parliament, for example, to be able to debate. But potentially you could have a petition that led to a requirement for presumably the UK Parliament to consider this issue. The danger with these kinds of requirements always is how do you get them to genuinely consider it, rather than just have a bit of a tokenistic debate. And it's just really difficult to make that work, I think. But I mean, in principle, I kind of agree with you. You know, the way you set up the question, I think you're exactly right. But I just struggle to see a mechanism. But if others on the panel can see a mechanism, then perhaps there is something in this.
Anyone got the secret plan?
Does anyone else want to come in? Yes, Dr. Cassidy.
I'm afraid it's not a secret plan, but it is a comment, because I mean, I completely agree, because this is about the people. And I suppose one comment that I would make is that, you know, in a way, the citizens of Scotland are sort of pushing this by coming out in Scottish Parliament elections and voting for pro-independence parties. And sometimes, you know, this isn't maybe recognised enough, the importance of this. And Nicola was talking about this code of practice that we both worked on. And it says, you know, well, if you can't have a referendum, another way of taking into account, you know, the views of the citizens, of the people, is through subsequent elections. So I think we have this, and this is clear, and sometimes it's underestimated. What sometimes people do say about elections is that, well, you don't know why people are voting. You know, this is the criticism that's made. You don't know why people are voting for these parties. Maybe they're just happy about the way they're governing. It's not really about independence. This is the counter-argument that's always put forward, which is why people say, well, you need a referendum, because this gives you a clear yes or no answer on the specific question. Because they say, well, with elections, you never know. But I would say, you know, the importance of these election results, I think, sometimes is underestimated in this context. Something that I was just thinking, it's not the magic solution, but something that maybe could be organised, or either some citizens' assemblies or some deliberative kind of sort of procedures involving citizens, maybe talking about, you know, different avenues. Which avenues? Because it's already come up. There are different avenues. Should it be one referendum? Should it be two referendums? Talking about options, so maybe broadening out the debate to sort of increase support, to increase visibility, to keep it in the kind of public sphere, maybe opening up different kind of questions to sort of build this momentum. But I think thinking about what citizens can do, I think the elections, you know, coming out in elections and voting is the clearest way of making their views heard, and that this, I think, should be taken into consideration, and I'm not sure it fully is, so this would be...
I mean, I think it should be as well, but it hasn't been so far.
Yeah.
I think so. If you look at the responses from successive prime ministers when requests have been made, it's never been no, it's been now is not the time, which is interesting because that does sort of link back to the implicit acceptance of the principle that the union is voluntary and Scotland or another constituent territory can leave it. I have a bit more sympathy for a deliberative process than Alan does. And Alan and I both served on the steering group of the Citizens' Assembly of Scotland, which sort of tried to get to this, but with questions that were way too vague, I think. If we were to do something like that again, I would recommend being much more precise about what the ask was. It can't break the deadlock in the sense that the legal authority rests with the Westminster Parliament, and that's what we know. What it can do is make it perhaps, if there was a consensual view emerge from a citizens' forum of some kind that that wasn't just from a pro-independence party, but it was from a process of learning and negotiation and compromise that emerged from citizens, and it's a little bit harder to ignore all the other sort of contributing factors. And of course, now is not the time becomes weaker the further from 2014 you go.
Yeah. Thank you.
Thank you. I wonder if I could ask a couple of final questions. I feel I have to make the case for Cornish independence, since we've talked about other parts of the UK today as well. I recognise that ask too. But it is getting really, really messy. I think the point you made about the possibility of having regional legitimacy to referendums and looking at it on an area-by-area basis. When you look at the EU referendum, of course, you know, there's a definite difference in Scotland to the rest of the UK, but we're still pulled out. And yet, we now have a differentiated relationship with Northern Ireland and the EU, Scotland, and it just seems that over time, devolution is stretching the capability of Westminster by convention to do these things. So, do you think there is any merit in revisiting a constitution for the UK? I don't know if anyone wants to come in
on that point.
Professor
First.
Yeah, thank you, Dr.
Thanks very much. I think that's a very interesting point. Obviously, writing a constitution, I don't think would really solve any of these problems. I mean, what it would do is kind of open them all up to discussion as to what we put in the constitution. So I don't know if writing a constitution per se would be the solution. What I might say is that, and I think I mentioned this before, you know, the issue of independence is obviously connected with the issue of the kind of devolution, the devolved state, how that works with the union, because it doesn't directly map on, because we have kind of parliamentary sovereignty. So I think all these questions are connected, and thinking about them as being connected is maybe a way also of making it less black or white, because there may be debates about, I don't know, a federal UK. What could a federal UK look like? How could we give Scotland more voice, more recognition? How could we also recognise these other territories, you know, Shetland, Orkney, and what status would they have? And then there's an argument that you could have some proposal, you know, on the ballot, or you could have a referendum, but that has independence, and then this improved kind of model of devolution, this intermediate kind of federal system, that kind of makes it less black and white, and is another way to maybe try and resolve some of these issues. So I think it's an interesting point. Obviously, it would open up a whole other set of complexities and difficulties, because it wouldn't only be the territorial question. I think the moment you have to write a constitution, you have to address a whole other set of questions. So it's complex, but they are arguments in the sense of saying, well, if this is a problem, if the model isn't working, if there are too many problems, let's think about how can we really make it work? How can we make it better? We really set it out in a constitution, And then we can say the people of Scotland can choose, the people of Shetland and Orkney. Everybody can come out and vote. Do they want this new proposal, or do you prefer independence? And it's a way of, giving people a voice, but also trying to sort of address the issues.
Does anyone else want to come in on that point? I'm not seeing any hands going up. Oh, sorry, Professor Black.
Yeah, on a written constitution. I mean, I've supported in the past a written constitution for the UK. I still support one. I'm aware there are lots of arguments against one. Some of them straw person arguments, some of them legitimate arguments. But in a sense, to address this issue, it would be the most clear means by which you could come up with rules which could actually be justiciable and would actually apply to the UK Parliament and the UK government. So if you wanted to come up with a mechanism that was actually above the whole system and was a means by which a referendum could be triggered, in theory, a written constitution is a way, possibly the only way you could do that in law. That doesn't mean it's simple, but it would address that issue. I wonder if you were trying to sell to the whole UK that we need to do a written constitution to resolve an issue involving Scotland, that would be that wouldn't be my way in to selling it to the whole UK personally, although I do recognise this is a really serious issue. I recognise it, but I wonder about the politics of that. Then if it was going to be a constitution which, again, this would be unusual internationally, as the committee's already heard, to have some kind of clause in it that allowed bits of the UK to leave and set out by the means by which they do so, you would then be opening up, and this has already been mentioned, can Cornwall leave? Can Wales leave? Can Yorkshire leave? Can England leave? It would raise all kinds of those questions. And obviously Northern Ireland as well would be complex and all of that, because we wouldn't be able to do something which, in a sense, differed from what's in the Belfast Good Friday Agreement. So it would, while I agree with the written constitution, I can see that legally it could deal with some of what we're talking about today. I think it would also, as was just said, open up a whole range of complexities that actually, if you're trying to get a written constitution done, you might want to, my view is a written constitution at first at least should be a minimalist written constitution, and this might be something perhaps to come later, but not in the first tranche. So we're talking about a longer time frame on that. But I do agree that the written all that's being talked about today in this inquiry, a kind of background to it, is the UK doesn't have a written constitution. That's one of the reasons, not the only reason, one of the reasons it's difficult for us to conceive of a mechanism that's without the control of the UK Parliament, because we have the doctrine of parliamentary sovereignty.
Okay, does anyone else want to come in? I'm going to go to Mr. Brown.
Thanks very much. I'm just conscious that in 1979, I was 17. I tried to use my mother's to be a proxy for my mother's vote in that referendum. At 17, was too young to do that. And I'm just thinking about all the different conditions which have been applied. And just to see if any of the witnesses can say, what is it that's so different about Scotland? So in 1979, we had this 40% rule, unheard of, where the votes of the dead counted for the status quo. We've talked about confirmatory referenda, and I think, whilst I see some merits in saying what is the final shape of an independent Scotland to be, being subject to a vote, I see some merits in that. The idea of having to say again that we want the same thing, I can't think of anywhere but Scotland that would be the case. The idea that we would have different parts of Scotland, I know this has not been advanced by the witnesses, but it certainly was by Jamie, different parts at the same time could vote differently. It's funny because I didn't recall those voices during the Brexit referendum when every part of Scotland voted to stay in the EU and were utterly disregarded. So that didn't count at that point. Also, I would say that if this is merely a distraction and the SNP are not serious, but call our bluff, go for it, have the referendum, that's the best way that you can kill it off. But why is it always that we come up with these strange mechanisms or different conditions which you'd apply? Compare it to the Brexit referendum, no white paper, no background to it, no conditions attached to it. And the point about 50.1%, well, it was 52-48. Nobody's questioning its legitimacy. It's a simple majority. Why is it only these conditions seem to be talked about or brought into the equation when we talk about Scotland? Is it simply because the Brexit referendum was won for its own reasons that the Prime Minister of the UK wanted, and the independence referendum is a referendum that they don't want? Or is there something specific about Scotland which we can't quite discern that makes it subject to all these conditions? Anyone? Unlike yours, Neil, which is pure academic.
I don't think it's specific to Scotland. I mean, obviously, it's very common now, and I think it's maybe particularly relevant in Scotland after the Brexit referendum because of a lot of the problems that arose out of that referendum. But I think, as I flagged in my evidence, we kind of carried out a report that I was on for kind of Catalonia to try and break the deadlock between Catalonia and Spain. And a lot of the options that we considered there, obviously they were located within the Spanish framework, but we considered very much the similar thing, you know, should we have a kind of trigger referendum, a kind of initial sort of referendum to see if people wanted, or also the option about having what we called kind of a ratification referendum at the end once it had been agreed, and the option of two referendums. I think this comes out of discussions on referendums more generally. I think it's agreed that in a way they're imperfect. So in the same way as elections, they cover a whole range of different issues, so you're never really sure why people are voting for a certain party. Referendums are kind of black and white questions on one issue, but people say, you know, sometimes they're imperfect because if you're asking for a very big issue, you're asking a big constitutional question and it's just 50+1, does that generate instability if there's a kind of change in the mood shortly after? So I think people highlight some of the issues. What if there's a very low participation, for example, but then it ends up winning? Should this be considered the outcome? So I think there's issues that people raise with referendums as decision-making sort of instruments, which lead to these kind of considerations when experts start deciding, well, what is the best process? So I don't think it's just, I think it was just to say, I don't think it's just for Scotland, but I think it's also important to think then any solution that is adopted should be a specific Scottish one. And I think, as I've said already, you know, the 2014 referendum on independence is, and Stephen Tierney was talking about this in the previous session, you know, it's internationally recognised as an excellent exercise of kind of self-determination and deliberation. And I think it would have been decisive had it not been for Brexit, which kind of changed the circumstances. If not, I think we'd be having very different conversations now, or we would have been. So I think in the Scottish case, we have that precedent, and any departure from that as to kind of trigger and requirements or circumstances, I think it would need to be negotiated and it would need to be justified because we have that precedent and it worked.
Just on that, my last question, just on that point, and you mentioned earlier on that we actually have an off-the-shelf agreed solution as to how this should be conducted, but that's not going to be agreed to by the UK government. And you made the point that it's at times of relative calmness when you can perhaps get more chance of an agreement. And also, I think you very helpfully mentioned the extent to which, if you want to see a referendum, broadening it out and having a more discursive approach to it could be beneficial. And Patrick and I are involved in the early stages of setting up a convention to that effect. However, if it's the case that the UK government continues to say no up into the election, and if the election returns the majority, which certainly I would hope for, then there's very little chance at that stage. I mean, I can see the UK government coming straight back and saying, well, let's discuss the ground rules again. There's very little chance of getting any agreement at that stage. The chance will have been gone. Very similar to in 2014 when they promised all these things like enshrining Sewell Convention in law, putting the Scottish Parliament on a firm footing and making it a stronger Parliament. The exact reverse happened afterwards. So there's very little prospect, would you agree, of after the election of getting any kind of the calmness that you said is necessary to ensure that, so it'll be straight into a kind of binary approach again. Would you agree?
Obviously, I'm a legal expert, so the kind of more political dimensions of this, I'd rather not go into. Nicola might be better placed to discuss this, but I think what's important is to maintain so thinking about this ongoing refusal at the kind of UK level, the level of the UK government, I think it's important to maintain the pressure, to maintain the momentum, to maintain the discussion and the request, because obviously something that came up last week, I know in in the evidence was the idea of kind of international recognition and international legitimacy. And I think this is very important. And we saw in the Catalan case, because they really pushed ahead at the end and they kind of pushed against the legality, maybe this didn't fully follow. But I think before that, they had a degree of international recognition about what they were doing and building this momentum. So I think this is also important, because this also then results in pressure on the UK and the UK authorities if there is this kind of ongoing momentum and pressure and there is no response. Because as I said, we have the principle of parliamentary sovereignty, but also, a core principle of the UK constitution is the principle of democracy, the principle of the union. These are also important points that I think come in.
Oh, and your last question as well, so I'll go to him first.
I think you referred to me. Sorry, the microphone didn't come in until after you mentioned the name.
Sorry, I thought you wanted to come in the last. So sorry, I missed that on the last question.
Yes. So I might. Okay, quickly, just on the written constitution question, I would say that in principle it would be desirable for the UK to have a written constitution. However, the process of getting there would be like the process of negotiating Brexit times 10. And I think the benefits of having a written constitution would actually not be sufficiently great to justify that kind of process. So I think it's important to clarify specific points, such as preferably the one around when a referendum on Scottish independence would take place. But I wouldn't try to write a whole written constitution. On Mr. Brown's question about why is Scotland being treated differently, I very much agree with Elisenda's answer that I don't think Scotland is being treated differently. And one point here is that, as was very clear from the evidence in the previous session, it's actually quite unusual the degree to which the principle of Scotland's right of self-determination is recognised in UK constitutional practice. But regarding the particular form of referendums, I've looked at referendums a great deal, a little bit before the Brexit referendum and a great deal since the Brexit referendum. And I think what we saw in the Brexit referendum was that having a really momentous decision made on the basis of one vote, one national vote, without really thinking very carefully about the procedures around that vote, and without ensuring there are opportunities for making sure that there is some stability in the view that has been expressed in that vote, is inadequate and doesn't lead to loser's consent, that term that again was used in the phrase in the session 2 weeks ago. And you suggested, Mr. Brown, that vote is accepted as legitimate. Yes, but with great reluctance. Millions of people signed a petition in the wake of that vote protesting that it was an illegitimate outcome. Many people would still argue that really it was an illegitimate outcome, even if they accepted. And as an independent Scotland does not want to start in those sorts of circumstances. And I guess maybe to go back a little bit again to Northern Ireland, though I completely accept what Mr. Bibby said about the fact that the cases are very different. There's a lot of thinking in parts of the nationalist movement in Northern Ireland and also in the Republic of Ireland about the circumstances in which they would want a united Ireland to develop, and a lot of concern that if a united Ireland emerged in circumstances of great division and conflict, then that would be a very poor start. So I think these kinds of issues arise in many different contexts, and the question of how can a decision-making process be designed that allows the democratic will of the people of Scotland to be expressed, but allows that will to be developed and formed for people to think about things seriously, and allows some confidence that this is indeed a decision that will stick and that people will remain confident in. That's a really important thing to try to do. And I guess all of the evidence that we've been discussing in these sessions has been oriented towards thinking about how can you achieve that.
Okay, Professor McEwen.
I mean, I agree with a lot of that, and I think that it's really important that the referendum, should there be one, is perceived as fair on all sides of the debate. And I think the 2014 referendum was perceived in that way. I think that, and given that that's the way that referendums have been conducted in the United Kingdom, I think probably a departure from that would be perceived as unfair. And the 1979 referendum was definitely perceived as unfair, given the threshold that was imposed at that time. But I do think it's really important that there is a deliberative process in advance of a referendum, so that we can be as sure as possible that the decision is as informed as possible, and reflected upon, and is a decision that, as Alan said, would stick and would be stable. There is no right and perfect way to do this, but I think it's that perception of legitimacy from all sides of the debate is absolutely crucial and important to remember, and we saw this with Brexit. It would be even more the case with an independence referendum, is that the referendum is the first step in a very long process of negotiating and transitioning to an independent Scotland. So if you want to ensure that the people come with you on that journey, then that perception of the legitimacy of the process that led to it is all the more important.
I don't disagree with the points about ensuring it's fair, and the point about a process leading up to the referendum I accept as well. It's just that there's little point in doing that unless you're going to have a referendum. I think that's the point that we're stuck at. And on Professor Renwick's point, I think empirically the evidence doesn't support your statement that Scotland's not been treated differently. 79, even 97, asking a second question was a very different mechanism in a referendum. And the second point, or the other part to that I was making, was the way that we're treating it different just now by talking about maybe having a coincidental referendum for part of Scotland during the same time, or imposing something like the settled will, or a supermajority, or all these different conditions which would apply. The point I'm making, none of that was involved in the Brexit referendum. And it's fine to say, let's learn from the mess that was the Brexit referendum. But it's the way that the state is perceived to treat different parts of the UK differently is the point I was trying to make. But very grateful to the panel for the answers they've given.
Professor Blick wants to come back in as well.
Yes, on the point of whether Scotland's treating differently, and if so, why. I mean, I think in 1979, I believe it's the case that the threshold was applied to Wales as well. It's just that Wales voted no by majority of those voting anyway, so the threshold didn't kick in. But I suppose, but the answer to that again is the point I made at the beginning: is politics. The reason that the threshold requirement was inserted was because of divisions within the then governing Labour Party over whether they actually wanted this to happen, over the issue of devolution, over the issue of the referendum itself. And I think some of this, and the way in which the referendums have been different subsequently, and whether or not we hold a referendum on a particular thing, is again to do with the ad hoc way in which we've handled referendums in the UK up to now, and unless something changes, we'll continue to handle them. And that's why the politics is so important. And often I think the pattern has been that referendums have got a lot to do with the internal politics of whichever party is in power at a given time, or whichever coalition of parties is in power at a given time. And I think, likelihood, I think, is that a future Scottish independence referendum will be determined by politics, particularly the internal politics of whichever party or parties are in power. And we've got to be aware of that there are many different forms in which circumstances in which a referendum could happen. There could be circumstances, political circumstances, in which it's seen that there's very, very large support for independence. Both sides accept the game is up. I mean, this may sound a very optimistic kind of version, and it's all pretty amicable. you can have two referendums. You have a first referendum in which there's a large majority, a second and then a negotiation period in which the remaining UK accept that this is what's going to happen, and negotiations are fairly cordial, and then it's confirmed by a second referendum. I can see how that could make a two referendum option attractive. There could be a completely different situation in which a referendum is wrung out of the teeth of a government somehow, and it's all very bad-natured, and there's a very narrow result one way or the other, and maybe if there's two referendums, there's a negotiation period in which the remaining UK government wants to be seen to be as tough as possible. And that, so there are many different ways in which it can happen, and I think whenever we think about mechanisms or how things might play out, we need to be aware of that the politics of the time are going to play a huge role in whether the referendum happens and the way in which it plays out. And I don't think, although it's absolutely right, I'm really pleased the committee's looking at mechanisms, and it would be great to get towards a clearer mechanism. I think the lack of a mechanism is definitely a problem, but I think we have to still have to appreciate the politics is going to be in there.
Thank you. Mr. Johnson.
Thanks, Gabina. I was going to ask the panel as a kind of final point whether they think that any party or a political party or any government that was serious about independence, serious about being honest with the public, would publish any secret plans that they have for independence and referendums ahead of an election which they're asking people to vote on. But I feel I might be getting slightly into the politics of that, and unless you particularly disagree or have a point on that, I'd be happy to leave it there. You've talked about the secret plan. Keith knows for sure what it is.
So I'm not going to press the panel to respond to that one at all. Can I thank you all for your contributions this morning? It's been a really interesting session. We now move into private session. We've got some more business to discuss. Thank you very much.